Yes, sir.
Could you comment on the Fulton County Commission
Time
applying
to leave.
to
Tennessee.
on their appeal to the
Rusty
Justice
wants
Department on the redistricting?
Okay, so there's really two issues there. Number one, you don't really expect the Fulton County Commission to submit paperwork to the Department of Justice. So at a given point, that would require a mandamus action filed against Fulton County to bring that forward to DC. And you'd want numerous months to go by before that was occurring. At the same point, when they would potentially do that, you don't really expect Fulton County to say, we like this legislation. So it's going to require third-party groups to be actively involved. And I would suggest that the Department of Justice would view with disfavor such a request, whether it was legally appropriate or not. So you're really looking at action in federal court a year down the road at that point. There's a current case in the U.S. Supreme Court on Section 5 of the Voting Rights Act of 1965, which will decide whether Section 5 is constitutional or not. If Section 5 is ruled unconstitutional by the U.S. Supreme Court, then you would be left with Section 2, which would make that lawsuit a totally different process and in all likelihood much easier to compel. So I think a lot of people on the legal side would be waiting to see what the Supreme Court does, because remember, their decisions have to be out by the end of June. So you're talking 2 months for that decision. So you've got Section 5 on the one hand, and then you've got probably 2 sets of federal litigation if Section 5 is upheld. Now, let me mention to you about Section 5 so that folks understand Section 5 a little bit more. If Sandy Springs wants to change a precinct boundary for Fulton County, that's a Section 5 preclearance. If you do a vote on a bond to build parks, that's a Section 5 preclearance. It's not just elections with candidates. It's everything. But due to the breadth of Section 5, I mean, I found it astounding that when I wanted to do a vote, a SPLOST that included, for instance, building parks, when I chaired Cobb County, I needed to do a Section 5 preclearance. So I think the public perception of what Section 5 does versus the legal reality are two different things. So from my perspective, when any government seeks to reduce minority representation, that government should be sued, and sued big. Because I totally support the fact that you should never dilute minority voting. But the process should treat everyone fairly. And under Section 5, you're guilty before you're proven innocent. And I don't really think people in Georgia are any better or worse than people in Massachusetts. So you have jurisdictions around this country that absolutely do not pass the test for Section 5, but because they passed it in 1964 or 1965, they're not part of it, whereas they would be part of it if the same test were applied around the country now, and that's not fair. For those states that have changed, for those states that treat people fairly, we shouldn't be part of Section 5. And there may be a whole other group of states that need to be part of Section 5 if we're going to have Section 5. But why are we still using data from the mid-60s? You know, I don't tend to think we're the same state in any way, shape, or form as we were in the mid-60s, and I think that's something we should all be proud of. So, you know, when I go around the state, if you go to a GMA or an ACCG conference, counties or cities, look at the minority representation of that in that room. Absolutely different than the 60s. If you look at the legislature, you know, absolutely different. And it is ridiculous that in the year 2013, we're making believe we're still in 1964. You know, the states changed. They let Yankees like me in, you know. Now, having said that, I'm from Florida. I never knew I was from New York till I moved to Atlanta. Yes, sir. Yes, Mr. Reporter.
Can you clarify something on the Voting Rights Act real quick? It was my understanding that the new cities were exempt from Section 5.
The new cities, if you don't have a history, then you're exempt. So I should have said Fulton County
You
instead
can
of
apply
saying.
for it and get an exemption.
Right.
That's what we did.
Thank you, absolutely. But the problem is the existing jurisdictions, no one really has the faith that it will be approved. So you're not seeing those applications, which is the importance of the Shelby County case that's now in front of the Supreme Court. I mean, the truth of the matter is, well, I mean, that's what I said before. You know, if any government dilutes or seeks to dilute minority voting strength, they should be sued. And they should be embarrassed, and, you know, the whole routine, whether it's a city, county, state, you know, they should be, minority voting rights should be protected. But Newt Gingrich was right 30 years ago when he said that Section 5 of the Voting Rights Act is going to create districts that have higher and higher minority voting, and will absolutely be contrary to the American history of the melting pot. So if you look at each decade, the minority seats have a higher voting percentage, and that creates where there's really no November election in our state, you know, where it's the primary election rather than the general, and that's not healthy. Because what happens is then you start having more and more opposition in the primaries because folks actually want there to be an election. And that leads to the extremes on both the left and the right in those primary elections, rather than where most of the public is at that point. So, I mean, it's no surprise that John Lewis's district has a higher minority percentage now than before. It's no surprise that some of us in the suburbs, you know, have higher percentage of Caucasian voters as a result of those actions. And, you know, there ought to be commonalities. It ought to be, for instance, if you're in the city of Marietta, you ought to try and put folks all together that live in the city of Marietta. You shouldn't slice and dice it specifically due to what's required now in the Voting Rights Act. Look, there was a case in Kingston, North Carolina, where the town's two-thirds black, and they wanted to go from partisan to nonpartisan elections for mayor and council. And they had a vote, and two-thirds of the citizens of Kingston, North Carolina voted to go from partisan to nonpartisan. And the Justice Department said no. And the Justice Department wrote a letter that if you don't have a political identity next to the person's name, how would the minority voters know who to vote for? That's in a Justice Department letter, okay? So Kingston, North Carolina, which is two-thirds black, sued the Justice Department, okay, under Section 5. And then when it was coming to a hearing, someone in the Justice Department decided, you know, that was really stupid and a really bad fact pattern, because they're then seeking to have Section 5 ruled unconstitutional. And the Justice Department said, we withdraw our opposition, you can move forward. So I mentioned to you that the Supreme Court took the Shelby County case. There was a request to take the Kingston, North Carolina case too, and the court chose not to and just took the Shelby, because the theory being that that case may be moot now, because they told Kingston, North Carolina, years later, you can have your nonpartisan voting. That's the kind of absurdities we're dealing with here. So you're right, it's by definition a political process. But you get to vote, and you get to vote for who's elected. And I would suggest to you, if there weren't a Section 5, it would be a really strong argument to tell your elected officials that say the people of Sandy Springs should have the same state senator. I mean, that's common sense.